guys. Well, Stowe can watch this. We have a new board member. His name is Stowe Boyd. He'll be joining us hopefully next month. He's not feeling a little under the weather tonight. But him and I have been in touch, so I kind of gave him the rundown of what the responsibilities are. We talked briefly about the applications. Not that that matters so much anymore, but I will be making sure that he watches this, because today's topic, what's going to start us off for the year, is an overview of the responsibilities of the Zoning Board of Appeals. So I put together a fresh new PowerPoint. I'm pretty pumped about this. I spent all day Monday working on it. So it's pretty good. Although constructive criticism is appreciated, so it's okay. So let's get started. The format of this presentation is that I've kind of interspersed questions throughout the presentation. And after each question, we'll talk about the answer and why the answer is what it is. So instead of an A, B, C, D, all the questions have numbers. So I'm going to read the question. We'll read the answers, and then I want you to hold up either 1, 2, 3, or 4 for the answer. Okay?
I like that paperless, very good.
Right? I know, I didn't want to make tabs again. I was running a little bit behind, and everybody lost them last time,
good.
so we're doing numbers today.
Very good.
So let's start off with, what is zoning? Is zoning a land use tool designed to help implement a municipality's comprehensive plan? Laws that organize how land may be used? Laws that govern how large buildings can be, how they are built, and what they are used for, or all of the above?
Are we doing individual?
No, this is great, collectively, great.
okay.
You guys are all correct, so we're off to a good start. The state of New York grants authority to municipalities to enact local laws to perform governmental functions through its constitution and its statutes. Future growth and development of the municipality is controlled by zoning, which furthers the objectives of the comprehensive plan. Zoning regulations include specifications regarding lot size, density, bulk, height, and floor area ratio, just to name a couple things. Now, the comprehensive plan is the culmination of a planning process that establishes the official land use policy of a community and presents goals and a vision for the future that guides official decision-making. So the City of Beacon updated its comprehensive plan or master plan completely in 2007 and then adopted a comprehensive plan update in 2017. You want to do this about every 10 years. Some municipalities do it shorter, maybe every 5. Some municipalities haven't looked at their comprehensive plan in like 25 years, but this is your plan for the future, and things come up that require the comprehensive plan to be updated, to change, to reflect the goals of the municipality. Now our goals might focus more on electrification of buildings. Back in 2007, that definitely wasn't a thing that would come up. So 2017, we'll probably look at this again, maybe 2027, so like I said, every 10 years. Now, zoning has 3 components. It regulates the uses allowed in each district. For example, districts might be divided into their simplest form as residential, commercial, light industrial, and heavy industrial, with specific uses permitted in one or more districts or some combination of uses. Zoning regulates how intensely uses may be developed by setting minimum and or maximum lot sizes, aka regulating density, and restricting the number of residential, office, or other units allowed in buildings within zoning districts. Density can also be regulated by establishing setback requirements or minimum lot sizes, things like that. And then zoning regulates where on a parcel primary and accessory structures can be built. Again, through setbacks, height limitations, limitations on buildings in certain areas, such as floodplains or steep slopes. So now we have our next question. Where do New York municipalities find the authority to pass zoning regulations and appoint zoning board of appeals? Is it in New York State statutes? Is it from their planning boards, county legislatures, or common law? You guys are great. That is the correct answer. So general city law, which is a state statute, section 81B, establishes zoning board of appeals. Now, that's really interesting because that section, unlike planning boards and unlike maybe your architectural review boards, the state law says that every municipality with a zoning code has to have a zoning board of appeals. It is not a recommendation, it's not a may, it's a shall. You have to have it, and that's in 81B. And then our city code, section 225/55, also kind of reiterates what's in the general city law, and sets forth the, use variance standards, what the jurisdiction of the zoning board of appeals is. So the authority does not come from the city code. Our city code mimics what is in the state law. Now, the role of the zoning board of appeals. First and foremost, you guys are a public body, and we've talked about this many times and what that means. I mean, you are subject to the open meetings law. All your discussions about applications have to be made in public, or all your discussions about city business at all have to be made in public. You have to have your meeting minutes, your decisions have to be made available to the public and filed with the clerk, all that good stuff. Like I said before, every municipality with zoning has to have a zoning board of appeals. You guys act as the safety valve. You keep the zoning restrictions from being overly rigid. There has to be some flexibility to accommodate for unique circumstances, right? You exist primarily for your appellate function. You act as a buffer for aggrieved applicants between decisions of the zoning enforcement officer or the building inspector and the state Supreme Court. So instead of suing the city for everything, a lot of those issues can come to the Zoning Board of Appeals for discussion. And the state requires that you do at least 4 hours of training. So that's why we have these training sessions before every meeting, so that you satisfy those requirements. And we've talked about that training before. You are free to do more training. Those hours can carry over if you do more than the 4. If you find an interesting program, feel free to share it with all of us, and you can do training that way. But we've talked about that plenty of times, so I don't want to bore you too much. But any training questions, always just shoot me an email and we can talk about that. So what functions must Zoning Board of Appeals always perform? Review of use and area variance applications, interpretations of zoning and the rulings of the zoning enforcement officer, site plan and special use permit review, both variance review and interpretations of zoning enforcement officer rulings, variance review, interpretations of zoning enforcement rulings, site plan review, and special use permit review.
We don't have to special use permit anywhere, do we? Just one?
That's a good one.
Interpretation. Doing one today. Site plan, special, we don't do special use anywhere, do we?
Hold, we're just waiting for, I'm missing one.
I'm sticking with my original.
What'd you do? 5 minutes?
I'm kind of stuck between two of them.
Well, just throw up a number and we'll talk about it. Okay, that's the right answer. So
What is it for?
we regularly do use and area variances. Everybody got that part right. What is not an always requirement are site plan and special use permits.
Right.
Municipalities are free to give the zoning board more authority if they so choose. But what is mandated in general city law is that a zoning board exists to review interpretations and to review variances. You are not there, you do not exist under general city law for site plan review or special use permit. So this one was a little tricky. That's not to say the city can't grant you those, that review authority. But the question is, what functions must the ZBA always perform? And you are always responsible for interpretations of zoning and the rulings of zoning enforcement officers and use and area variances.
Who is the zoning enforcement officer?
I'm sorry, I should switch that. Zoning enforcement officer is the building inspector.
Okay, that's
Yeah.
what I assumed, then I
Is
was
it-
thrown off.
Is it the building inspector in the city of Beacon, or is it always the building inspector?
It is the building inspector in the city of Beacon. In some municipalities, they go by the code enforcement officer. Sometimes there's a zoning enforcement officer under a certain different title. But in Beacon, we just have the building inspector and the deputy building inspector. And they fulfill those roles. So I'll try and change up what phraseology I'm using. All right, another question. To appear in front of the Zoning Board of Appeals, an individual needs to have the zoning enforcement officer deny them a permit, to have the zoning enforcement officer cite them with a violation, to apply directly to the ZBA for an area variance in connection with an application for a site plan, special use permit, or subdivision plat, or any of the above to have occurred. Okay, so the answer is any of the above. The main route for the Zoning Board of Appeals is through the building inspector. He is going to be the one that gets you to the Zoning Board of Appeals. The thing you can't do is just apply to the ZBA without having interacted with the building inspector in some way. You need to submit some sort of application to the building department to get here. Nobody has a right just to come directly to the Zoning Board of Appeals.
Thank God.
What? So it could be for a permit granted, a permit denied, a decision on how to apply the zoning regulations, or the issuance of a citation or some other enforcement action that would then get you here. The state statutes do authorize the ZBA to hear a direct appeal when an applicant is submitting an application for a site plan, special use permit, or subdivision review, and you need an area variance application. But again, you're submitting an application to the building department first, they review it and determine that you need a variance, and then you come, well, then you go to the planning board, then you come here. So again, there's no direct pathway to the Zoning Board of Appeals unless you're submitting some other application or you have interacted with the building inspector. All right, so other potential applicants to the zoning board, like we talked about, an applicant for a land use approval or a permit, or a person cited with a zoning violation, a neighbor or other third party who stands to be harmed by the decision of the zoning enforcement officer. So again, in this case, the building inspector issues a permit, and the neighbor feels that they're going to be injured in some way, then they can make that appeal to the ZBA. So I guess in that case, they're not directly interacting with the building inspector, but the building inspector has been involved. Does that make sense? So you can file an appeal of the building inspector's determination within 60 days after the building inspector files the decision in his or her office. The category of appellants has 60 days from the date they obtain or should have obtained knowledge of the zoning the building inspector's decision to file their appeal. That time frame is in the city code. That's 60 days. You can appeal any decision from the building inspector or any other department, board, or we don't have any bureaus, but any department or board of the city. And so, for example, a planning board member, even one who doesn't live anywhere near the subject property, could appeal a decision to the Zoning Board of Appeals. Appealing a decision of, again, any department, board, or the building inspector.
Can you say that again, Drew? That.
Yeah, so anybody can appeal within 60 days a decision of the building inspector or any other decision rendered by a different department or board.
So if the city council granted a special use permit, someone could appeal that to us?
No. So it wouldn't be a decision. Those decisions go through an Article 78.
Okay.
So it would just depend on the city council's not one of those boards. In fact, the city of Beacon does not have a board I can think of where that would be applicable to.
Great.
Like if we had like, yeah, now that I'm like running it through my head, I don't want to mislead anyone. It is not, a decision by the city council would go to an Article 78, right? Just like a decision of the zoning board of appeals would go to an Article 78.
As would the planning
As
board.
would the planning board
Right.
go for an Article 78. That is set forth in general city law, that is set forth in the city code. But you'd appeal, really appeals to the zoning board of appeals are going to be made appealing a decision of the building inspector.
What would be an example of what you're talking about in another municipality?
I'm thinking of a decision of a historic commission that might get filed. You might be able to appeal that decision to the zoning board if you're appealing an interpretation that they had. You might also be able to, one other correction, let's say the planning board makes an interpretation of a zoning code provision and somebody disagrees with that interpretation. They could file an appeal to the zoning board of appeals on the issue of we disagree with this interpretation.
Now, can anybody appeal our decisions? Like if the board renders a decision?
It would be an appeal, it would be an Article 78. So there's nowhere to go after the ZBA except to the Supreme Court. But I guess in certain instances, like if, and I did have a case where the planning board made a decision, and that decision, they disagreed, they filed their Article 78, but they also sought an interpretation from the zoning board of appeals as well. So I guess that would be an instance where the decision of the board would go to the ZBA. So it's very specific. It's a little bit easier to say, okay, a decision from the building inspector could get challenged and would be reviewed by the zoning board before going to Supreme Court. That make sense?
Yeah.
Okay.
Thank you.
You're welcome.
Yeah, thank you.
No, these are great questions, because sometimes I'm putting this together and I'm like, oh, okay, yeah, this reading it on paper makes sense, but you have to think practically, how is this going to work in Beacon, you know? All right, so actually that was a good transition into interpretations of the zoning code. So an applicant may apply to the zoning board of appeals for interpretations of the zoning code. So an interpretation when he or she believes the building inspector has wrongly interpreted the zoning regulations, when they believe they want to seek an interpretation about what the correct method is for measuring required distances. Did they measure it from the door? Did they measure it from the property line? Which is correct? Only the zoning board can answer that ultimately. They might come to the zoning board with questions about a definition of a term and whether or not it describes a use allowed in a particular zoning district. Is this flower shop a retail use or some other type of use? So all those are like the standard questions for interpretation that could come before the zoning board of appeals. And we don't get a lot of those questions, but it's important to know that we can, and two, what questions we might look at, and then what the standard is. Applicants for interpretations most often believe their proposals are permitted by zoning, right? Like everybody thinks they're right. And although the building inspector has ruled otherwise, they might disagree with that ruling, and that's what brings them to the zoning board of appeals. In addition, neighboring property owners may also appeal for interpretations when they disagree with the building inspector's determination that a proposal does comply with zoning and qualifies for a building permit. So for example, the local zoning regulations in the village of Owen require that adult uses be located at least 500 feet from places of worship. The building inspector interprets the law to mean measurements are taken from the property line of the place of worship to the closest property line of the lot on which building proposed for the adult use is located. The applicant for the adult use appeals the building inspector's decision because she believes that the regulations mean that the distance measurement should be taken from the front door to the front door. So she was questioning the distance requirement.
Adult uses, huh?
What?
Adult uses, huh?
Adult uses, man. So when these interpretations come before the board, what happens? So the zoning board bases its interpretations on 4 general types of information. The first is past decisions. The past decisions that the ZBA has made on similar matters. How have you ruled on prior applications or on prior questions of interpretation on this particular issue? The current interpretation applied in the case at hand should be similar to what you've done in the past, unless new information or new policies have been established that would lead to a different conclusion, such as those based on new comprehensive plan or based on changes to the zoning regulations or changes to state law or city code. The second type of information is records of a governing board's discussions when adopting the zoning regulations. So minutes and recorded comments from meetings or hearings at which the zoning regulations were discussed by the city council might reveal to the ZBA what was intended when the provision up for interpretation was adopted and discussed. So for example, in interpreting the definition of restaurant versus nightclub, minutes of past city council meetings could have included concerns about proliferation of nightclubs downtown, or issues about traffic or lighting, and all those would help the the zoning board make a determination. Noise could be something that comes up. Minutes of meetings at which the comprehensive plan was considered may also capture a discussion that separates commercial uses, that a separate commercial district should be created to keep establishment whose primary business is serving alcohol and providing live music and entertainment off Main Street. So you're looking at meeting minutes related to adoption of the city code, meeting minutes pertaining to things in the comprehensive plan, all to give a little bit more insight about what the intent was. Why was this written the way it was? What are the goals? The third type of information is the ordinary meaning of the term. With no other guidance or evidence, the Board of Appeals might check common definitions. How is restaurant defined? How is nightclub defined? If these terms aren't defined in the code, you look at the Merriam-Webster dictionary or other dictionaries that are out there, or how other codes might interpret those terms. Finally, with no other guidance, a board may accept testimony and use discussions of the zoning board to arrive at a common sense interpretation. At the end of the day, you have to take a common sense approach. What makes sense? What's going to serve the community and achieve the goals that are set forth in the comprehensive plan and the city code? Now, ultimately, when you receive a request for an interpretation, you look at it and make a determination that you believe ought to have been made in the first place. That's the standard. And you use these 4 categories to make that decision. And you can look at what may have influenced the building inspector's determination, but at the end of the day, it is the zoning board's interpretation. So you need to make sure that it is supported, and we'd always have to include, as we always discuss, a substantial record documenting the reasons for the ultimate decision. And I think if we have a request for an interpretation, we'd obviously go through these standards again and talk about this in a little more detail. But this is just the overview presentation, kind of give you a little taste about all the things we do. Oh my God, it's just not enough time. All right, next question. How many parts of the 5-part area variance test must an appeal pass to receive an area variance? Is it all 5, a majority? It's not a matter of passing the test, it's whether the factors when considered together show a greater benefit to the applicant if the area variance is granted than a burden to the community, or the municipal board establishes that number.
Trying not to look at his answer. Trying not to copy.
So this is the 5-part area variance test, and we refer to that as our balancing test, right? You don't need to prove that, you don't need to demonstrate that you meet 3 out of the 5. You could just meet 1. But if that 1 is in support and the balance outweighs, the benefit outweighs any potential negative, then you're going to grant the variance, right? So the answer for this one is 3, because it's not a matter of passing. It's establishing that balancing test and looking at the benefit to the applicant over the burden to the community.
To me, that's the clearest way that's ever been stated in all the years that I've been here.
The way that was worded threw me off, I'll be honest with you.
That's funny. To
She
me,
was
it's the
feeling
first
so,
time it was clear.
so good about herself. and then
Well, no,
Montos
because
had to bring her
I'm
down.
actually not going to take credit for this. I was doing a lot of research, and the state comes up with some of their questions in their PowerPoint, so this one is a state question. And so I can't
That's the
say,
state answer, too?
that's the state, yeah.
For some
So
reason,
I'm
I
not
was
a-
thinking of a use variance. I don't know why.
Next time I'll underline the area variance
I'm
part.
far from a lawyer, and English is my second language, but that almost read to me like it was for the benefit of the applicant, not necessarily the community.
But it's that they get a much better benefit than any burden to the community. That's the thing, because I always had a hard time understanding that. Like, if it's a burden
Yeah.
to the community, it's a burden to the
Well, the way you're
community.
saying it, I get it, but the way that I read,
So
like this,
I thought that was clear. That always bothered me, all these years. It's
That's good. So it works for some, it doesn't work for others, but as long as at the end of the day, everybody realizes that it's a balancing test, and nobody has to achieve all 5 standards in this test.
Nobody'd get a variance because they're all self-created.
Yeah.
No more use variances, anyway.
Now, I have
I'd say
one.
we're done.
No, well, I have one more question, because I know we're just out, but I think to kind of, before we lead in, this will be like the cliffhanger, although I'll give you the answer, although I think you guys know. Which is not a factor in the area variance test? Is it whether an undesirable change would be produced in the character of the neighborhood or a detriment to nearby properties? Whether the benefit sought by the applicant can be achieved by a feasible alternative to the variance? Whether the requested variance is substantial? Whether the alleged hardship relating to the property is unique? And whether the variance would have an adverse impact on the physical or environmental conditions of the neighborhood? Oh, I'm sorry, I was looking down.
I'm not looking. I'm going to say 2.
Oh, boy, guys.
Did you all get it right?
No. Jordan got it right. Oh, and I'm sorry, Montos got it right. I'm so sorry.
What was the answer?
Montos, Jordan's hand was blocking your hand at first. My apologies. So the alleged hardship relating to the property, it doesn't matter whether or not it's unique. That is not a standard in the area variance test. 1, 2, 3, and 5 are, but there is one missing. Which, bonus question, which factor is missing?
They didn't even get the first question.
Is it the self-created hardship?
It is self-created hardship that is missing.
Jordan will tell you all of them are
I
self-created.
know. I was like, which one will I take out of the?
I will say that often.
Yes.
He's got me convinced. I've been sitting next to him so long.
So that brings us to 7:30. So next week, we'll pick up right on this slide. Maybe we'll run through these 2 questions again and go back into the area variance standards and the rest of our responsibilities. But before we move on, any questions about what we talked about so far? All right, cool.
So we'll have to go to summer school.
No, don't worry, I'm here. There's no extra summer school.
This was a very good one.
Thank you, guys.
really was,
Well,
very
I have 38 more slides, so.
38 more.
So I wouldn't have to keep doing the PowerPoint. I just did one big one, and we can talk about it. It'll probably last like two more months, and then we'll move on to the next thing. I'll make another fun PowerPoint. Stay
Thank you.
tuned.
Thank you, Drew.
Thank you, guys. Thank you for indulging me. Appreciate it. I need a bigger audience, though.
We're not the planning board, so. All right. I have a new intro to read. Thank you, Drew, for coming up with this. Good evening, and welcome to the January 18th meeting of the Zoning Board of Appeals. And my name is Jordan Haugen. I am the new chairman of the board. Hello, public. Joining us tonight are my fellow board members, and we're also joined by some of our consultants, or one anyway, our city attorney, Drew, and of course, the zoning board secretary, Amanda. Thank you for being here, Amanda. Bruce Flowers, the building inspector, normally joins us, but he is not here. The application materials that will be discussed tonight, including any proposed resolutions or other documents, will be available on the city's website. Also on the city's website is a link to the rules of procedures of the Zoning Board of Appeals. Before we begin the meeting, I just want to take a few minutes to explain our board's procedures. Today, we have 2 items on the agenda, one actual application, and then a request for an extension. Normally, if there were more, we would hear them in the order it was noticed on the agenda. We'll hear from the applicant, and then the board will open the floor to comments from the public. If you wish to comment, please step forward to the podium. When called upon, clearly state your name and address for the record. All comments should be directed towards the board, not the applicant or any of the city staff or any other member of the public. I don't think we'll have to worry about this, but please limit your comments to no longer than 5 minutes. And please refrain from repeating comments, although that's typically fine. All emails and other written correspondence will be sent, that has been sent to the zoning board secretary will be made part of the official record of the application. The Zoning Board of Appeals hears and determines, as we just learned, administrative decisions, petitions for variances, and other matters as may be required by the City Council or the laws of the State of New York. Our final decision on any variance must be based on the evaluation of the applicable statutory factors set forth in the general city law and city code. For example, we just went through them, but I'll read them again because this is the type of variance that we're going to be hearing this evening. For an area variance, we must perform a balancing test to weigh the benefits of the required variance to the applicant against the 5 factors set forth in the statute. So it's important, I think, when you are a member of the public and you are speaking, that you should try to speak to one of these 5 factors in your argument towards either supporting or not supporting the variance. And those 5 factors are: will an undesirable change be produced in the character of the neighborhood, or a detriment to nearby properties be created by the granting of the area variance? Will the proposed action compromise the character of the neighborhood? 2, can the benefit be sought by the applicant be achieved by some other method feasible for the applicant to pursue other than the area variance? For example, can a proposed addition be constructed in a different location on the property where the variance would not be needed? The applicant should at least explore the possibility of variance alternatives and explain why they may or may not be feasible. Number 3, is the requested variance substantial? Number 4, will the proposed variance have an adverse effect or impact on the physical or environmental condition in the neighborhood or district? And 5, my favorite, is the alleged difficulty self-created? Those are the 5 factors we must consider in a balancing test. I'll go through the use variance if we have a use variance application, and every decision must also be supported by evidence in the record. Thank you. Can I have a motion to open the meeting?
Motion open.
Can I have a second?
Second.
All in favor?
Aye.
Great. Can I have a motion to hear agenda item number 1?
Sure.
Oh, I'm sorry.
Yeah.
I forgot. We have a special guest. The mayor would like to address us. Thank you, Amanda.
Hey, everyone. I'm Lee Kiriakou. I am the mayor. I'm not here as an individual tonight. I have occasionally appeared in front of you, the planning board, the zoning board, as an individual, but I'm really here as the elected leader of the city. And I just have 3 things to say. One, and I did this with the planning board. Actually, Jordan, you heard this, and as did a couple of others. Oh yeah, you were there too, Drew, right? One is just thank you so much, and that your service is all volunteer. It's incredibly important, and I'm just ever grateful, and I'm glad you're here. I wanted to welcome your new member. He's decided to get ill instead, but that's okay. And I also want to welcome Jordan in the chair role. Don't they give you a gavel?
It took, I think, 13 votes.
They took it away from me, yeah. So that's the first one, because it's just that I'm very appreciative of that. The second one is I want to thank the supporting staff, and I want to ask them to help the volunteers on the board whenever you can. And, this isn't a terribly fractious meeting tonight, from what I can tell, but sometimes they are. And, the planning board has to take flack sometimes, and so do you sometimes. Usually that's reserved for the council, and I've discovered, in particular, in the seat I'm in, I get a lot of flack. And, it comes with the territory. But you're also volunteers, and I would just appreciate the professional and supporting staff to kind of help them when there is difficult times, to help them navigate through it. The third one is just that when the public's here, our job is to listen. I know that's very important to you all, and I hope their job is to speak what they feel respectfully. And, sometimes it gets hard, and you just got to sit up there and hear it. I get to do that a lot, but I, chose the seat, and I'm not just a volunteer, and you all are. So I was very pleased to sit through the training. I didn't get everything right. It reminded me I still am learning stuff. I really appreciate Jordan talking about what are the criteria when there's an area variance on the table, because you're helping the community to figure out how to express their views in ways that are determinative of your decisions. And I think that's really important. The council approves a comprehensive plan. The community helps put it together. That sits for 10 years. Then the council does zoning. And then the planning board, gets the job of figuring out the site plans and how it applies. And people think that the planning board can just do whatever they want. And it's hard, and getting them to understand what are the limitations and what are the ways to speak effectively as a community member on something that affects you is important. I recently talked to someone who's been coming to planning board a lot on a local issue, and I tried to give them, here's what the zoning is in the area, here are the ways to kind of ask and make arguments with respect to planning. Similarly, you discussed, Jordan, how one makes the right arguments that affect your determinations for an area variance, and I think that's great, right? Because your job, different than the planning board, is to overrule our zoning on occasion when it's appropriate, and that's a hard one to have. So I just wanted to kind of point those things out, both our role in listening, the help from the professionals, and just thank you for being up there. This board, the planning board, and also the Board of Assessment Review are three particular boards where it's important that we have people who listen, people who understand the criteria with which you're being asked to make decisions, and then who can do so objectively. And, I come from a professional background. I do have a full-time job still, besides being part-time mayor. And I think that we serve our community better by being as by the book, as opposed to who we know in terms of what we get done. And I just think this particular group has kind of crossed that threshold. And I know it made sense, maybe 30 years ago when we were more of an, kind of a compact and insular community, to kind of say, who do we know, and does that help us figure out decisions? But we're so diverse right now, and so many new people, that I think the way you do it is the absolute right way, and you do our community the best service by doing it that way. So again, thank you so much, and I appreciate the opportunity to speak. So,
Thank you.
yeah. And happy to field any questions if you got any. So, okay.
Thank you very much.
Thank you so much. So if I'm going to leave and go home and eat dinner, I'll get criticized for that too. But you'll still be here.
So yes, as Amanda reminded me, we need to take a look at the minutes from the December meeting and approve or edit same. Has everybody had the opportunity to take a look at the minutes from December?
Yes.
Yes,
Any edits required?
No.
I didn't find any.
Can I have a motion to approve the minutes?
Motion.
Can I have a second?
Second.
All right, all in favor of approving the minutes?
Aye.
Aye. All right, passes. Can I have a motion to open the public hearing on agenda item number 1?
Motion.
Second.
All in favor?
Aye.
Aye. You have the floor.
Area variances. So my name is Jason Littrich.
So we are being recorded, so if either you can speak into the microphone, or I don't know if we have, we don't have the hand.
This is fine.
That's fine to speak in that one?
Yeah.
Okay, yeah, sure.
So Jason Littrick of JL Architecture. I'm here to represent House Advancements LLC, and we're here to seek an area variance. And the main purpose we're here is because the property is a pre-existing non-conforming lot. We don't meet the existing house does not meet the setback limits on the side, nor the front, I believe. And the owner is basically, what we want to do is on the second floor of the existing house, it has 3 bedrooms and a very low ceiling height of 7 feet. And we also have the gable ends that make it even shorter on the sides. And let me just pull up what we have here for the existing, so you can see that. The main bedrooms on the second floor are very convoluted. They're tiny, they're very small, and they're kind of interconnected. And so what the owner wanted to do is, one, raise the height so we can get an actual 8-foot ceiling height up there and kind of reconfigure that space. And as we were looking at the spaces and realizing there's not a whole lot of room up here to make, because the house is a 4-bedroom house with the 3 bedrooms on the second floor, there was no way to get any real size bedrooms that work efficiently. So we propose to add an addition to the second floor, and that's where, let me just pull up that floor plan for you. So that's where we're adding, whoops, of course it's recorded. So we want to add to the second floor a 2 bedrooms and a new master bedroom and 2 new bathrooms to that floor. We're keeping that addition that we're adding within the existing footprint of the home, so we're not exceeding we're not going past the existing footprint into that setback limit. We're being very conscious of the pre-existing nonconformity, and even in the height, by raising that roof line, we're still under what the required height limit is for the zoning requirements.
May I make a suggestion?
So,
May I make a suggestion and
Sure.
a request? I don't know if this is acceptable or not, but it'd be ideal if you came up here and used one of these mics.
I'm sorry?
It would be ideal if you came up into this area with your easel. And you can use one of our mics, and then we
This
could all
one too?
follow your drawings as well with you.
sure. So I don't know if this will still pick me up, but right now, the existing house is a 1.5 story at 29 feet. And by raising that roof height, which we're proposing, we're still at 31 feet, and 35 is what's required. So we're still staying within the required height limit. And like I said before, we're not going to be extending past the side yard. We're keeping everything within that existing footprint.
One question I had, or we had in the pre-meeting meeting, was, can you explain the distinguish between the property line by possession on the survey and the deed line?
Hang on.
Sure, so if you look at the top line, right, so there's the dark line, which generally on a survey indicates the property line, is the property line by possession. And then inside of that line, there's a dotted line saying deed line. So I guess my question is, what is the explanation for that? Is there some type of claim of adverse possession that is extending the property ownership out to the dark line? Do you know?
Not that I know. I know the neighbors to the south do have a deed because they put in new steps and retaining walls that do encroach into their property. On this side, I'm not sure what the, that deeded line is that runs through there.
Okay.
Yeah, because I know the property line is, everything there, the fence, everything is on the property line.
Sure.
I was wondering how that affects it.
Well, so there was some discussion between the building inspector, Drew, and myself about what that was, and Drew and I hypothesized that might be an adverse possession claim, and we had hoped the applicant might know, but the applicant is not here. Obviously, his representation is not an attorney. I don't know, Drew, if we got any further than our hypothesis.
No, I think we were, as attorneys who do land use things, intrigued by the idea of the adverse possession. We don't see it, and it was very interesting because they have this new deed, but I'm also not an expert in reading the deed line, so it was just interesting why there were two lines on the property, especially because what was interesting about it is the existing house is shown to go over the deed line.
Right.
But not go over the property line. At the end of the day, that doesn't make a difference for the board's decision because they're staying within the footprint. They're not going any more over that deed line. They're not going over the property line. If there ever becomes an issue, then it's an issue between property owners, and the city is not involved in that. So it was more just a curiosity question. But in this case, because they are within the existing footprint, it does not raise any concerns for this board, if that makes sense.
Didn't help?
It helped. I just don't entirely understand.
Sure, so, well,
why
I guess,
it wouldn't affect it.
well, so, again, based on our hypothesis that it could be an adverse possession claim, the idea would be that at some point, the property line was the deed line. However, then this particular building or this particular property was used up to what is the property line by possession for an amount of years greater than 10, open and notoriously. And so if that occurs, then
it's theirs.
it's theirs by law. And so I don't know if that is what occurred here, but
What year was the house built? I'm sorry.
But what impact or relation does it have to the request here? If it's the deed line or the possession line?
well, it doesn't, as Drew said. I guess in theory you could argue if it was the deed line, then they'd be asking for a larger variance. The house would be out of bounds.
Well, it would be a larger, non-conforming already house. They're not asking for,
Correct.
yeah, got it.
I think Drew and I were just lawyer nerding.
We were just making things more complicated than they needed to be in a good old attorney fashion.
Did you bill every 7 minutes?
It's 6.
That sounds terrible. But it was just part of the broader discussion about the existing non-conforming of the house.
Yeah.
And I think seeing it go over the property line just shows that it is non-conforming, exactly.
Anyway, any other questions other than the D-line question from the board?
So what exactly is the variance that they're requesting? Just because if it's non-conforming already and they're looking to enlarge it, that's not allowed, right?
That is correct.
So that's what we're being asked to allow.
Correct. You are being asked to allow them to extend the existing non-conforming because they are extending it upwards.
Right.
That's the relief, that's the specific relief being
They're
sought.
making it larger.
They're making it, well, taller, but yes.
Area larger, yes, but not side to side larger, correct?
Correct,
They're
not
not
side.
asking for anything above and beyond what's already non-conforming.
Exactly. So the existing side yard setback is 1.25 feet, and the required is 10 feet.
Right. So it's just
And
because
that's
they're
what they're
enlarging
saying.
it. So if it's non-conforming, if you look to enlarge it in any way, that's not allowed. You have to come before the board.
You have to
Isn't that
come
right?
before the board to seek
As we've
relief.
seen many times
Many
in the
times.
past. Yep.
Yeah.
And just to confirm, as I believe was stated and is stated in the papers, it still meets what would be the height regulation in that zone.
Right, so it's within that, and it's not for a different use. So it's not a use variance at
No.
all?
No.
It's just an area variance, okay. Thank
Right,
you.
because it
I
is
just-
pertaining to the dimensional.
When I saw the two, I was like, is it two variances they're looking for, or just one? Okay,
Just
I
one.
understand.
And just for the board's knowledge, I looked it up on the parcel card. It says that the house was built in the year 1900.
Yes,
Yeah,
so
which
that
means it's
means.
before that.
Before that. That's the earliest year you'll ever find in parcel access, just for
Yeah.
kicks.
They won't even do like a historic home. It won't have the right year.
In Dutchess County parcel access, 1900 is the earliest year you'll ever find.
Interesting. So it's old.
Yeah.
In conclusion,
Yeah, so it was before zoning.
yes.
Clearly.
Yes.
Any other questions from the board? All right. Anybody from the public? No one from the public here.
But I believe we got a
We're all
letter.
alone.
Oh, yes, we do have a letter.
So should we read that into the minutes?
We should.
Yes.
Let me find it.
There we go.
Anybody have that handy? Do you have it handy, Amanda, somewhere?
Oh, I had it, let me see.
I was very concerned about bringing my new script, but not the email.
Let us see.
There it is. All right, no, it's mail dot. I can find it now.
Might be right here in my downloads agenda, but
I have it.
you know it.
Okay, yep. So this was an email received by the zoning board secretary from Naomi Cannon, sorry if I mispronounced that, C-A-N-A-A-N, of 123 East Main Street, to the planning board, zoning board. I would like to support the applicant's intention to construct a second story on 12 Eliza Street as long as the building as a whole, when completed, looks integrated, as though the entire structure were built at the same time. Thank you, Naomi. Is that the only email we received? All right. At this point, I will ask for a motion to close the public hearing on agenda item number 1.
Motion closed?
Can I get a second?
Second?
All in favor?
Aye.
Aye. All right. And let us, we need a draft resolution to look at.
Oh, I'm sorry. I thought Amanda.
I might have. Maybe I don't have it. Do you have a draft?
You didn't. Did you print?
You don't have a resolution?
I might. Maybe I might have dreamt
No, there's not one.
about it.
Okay.
Hold on, Jordan. I have one. I have one. I'm just gonna email it to you.
And we can just wing it.
Okay.
No, email it to me, please. Either email's fine.
Okay. Hold on, it's taking a little bit of time to load the emails. Here we go.
This is- We did this.
I'm so sorry about this. I'll be more careful.
Working out the kinks.
It's only the first meeting of the year, so.
It's cold.
You know, it's cold, yeah.
Did you get it?
Which email did you send it to?
Oh, I sent it to both.
Thanks, I have it, all right. My word's updating, of course.
Isn't that always the case?
Mm-hmm. All right. So as always, we are going to go through the 5 factors. And I believe, as our practice, Drew will write in our discussion as to. So can we have some discussion as to the first factor, which is as to whether an undesirable change will be produced in the character of the neighborhood or detriment to nearby properties, will or will not be created by granting the area variance.
No, I don't think it'll change the area.
I agree with that. I don't think it'll change.
I concur.
I agree. I think that particular area is kind of on top of one another. I don't think that this will create an undesirable change. It probably will be a desirable change to the character of the neighborhood. As to whether the benefit the applicant seeks can be achieved through another method feasible to the applicant that does not require an area variance.
I don't think so. Doesn't seem like it could now.
I agree.
I agree.
I also concur. As to whether the requested variance is substantial.
I don't believe it is substantial.
No.
Remember, guys, I need a little more. I need a
I
little
don't
more
believe
meat.
it's substantial, given the fact that it's sitting within the existing footprint.
Right, it's
And it's
remaining
only a
within the
s-
existing footprint.
I concur with
Almost
that. I think
just a
that.
half a
Sorry
story.
about that, Elise.
It's not raising the line substantially of the roof. I mean, enough for the inside, but from the out, it's not going to be.
I agree. I think.
Character.
Oops, sorry.
I'm sorry. I
you're
talk
done.
slow, I'm old.
I think, again, it is in the existing footprint. I think mathematically, if there was a variance, if the setback was not existent now, then it would be, but it is not. It's just a raising height-wise.
They wouldn't even need a variance if it weren't for the pre-existing nonconformity.
Well, they would need a setback variance. If they were just building an addition in the backyard with the same setback, they would need a setback variance, right? Because it's not being set 10 feet from the property line.
Be hard to build a house there, but zoning happened, so.
Okay, I stand corrected.
There we go. As to whether the variance will have an adverse effect or impact on the physical or environmental conditions in the neighborhood or district.
I don't believe it will.
I couldn't see how it would.
I can't see how it would.
Got any meat for Drew?
Nah, that's all I've got.
Sorry, Drew.
No, I think that the proposed variance will have a positive impact, not an adverse impact to the physical, I can't speak to the environmental conditions, but the physical conditions of that neighborhood will improve based on the plans that I've seen. And then, of course, as to whether the alleged difficulty is self-created.
Yes.
Yes.
Is it self-created? This one is kind of tricky for me because it was before zoning and it's non-conforming because zoning laws were made after it was built. So to me, it's one of the close calls that it probably is self-created because they bought the house knowing that, and now they're
Right.
going to change it. With given common sense, my common sense anyway, to me, it does not, it seems, yes, it's self-created, but in a very, very slim way.
Yeah, I think,
Is that,
Yeah.
I think it is self-created as the,
As they all
as
are.
the, well, no, the owner would have been aware of the restrictions by the zoning
Correct.
code when they purchased the property. If it would not be self-created if the same owner owned the property and then the zoning law was passed. That would be an example of it not being self-created.
There you go. Very
Right,
good.
there we go.
Very good.
And then, of course, the final, not a factor, but is this does the board feel that this is the minimum variance necessary and adequate to preserve and protect the character of the neighborhood and the health, safety, and welfare of the community?
Yes, it's not, it's only improving the area and the community. No?
Didn't know if you were done.
Oh, yeah. I'll raise a hand.
Montos?
I would say the minimum is you leave it as is and you live with it, but I don't think the ask is substantial enough to look at it as a negative.
I concur with that,
Montos, I think you put it beautifully.
yes.
And then prior to our vote, I just want to ask the representation of the applicant if they can comply with our normal restrictions. Again, I assume your client will have no problem paying any fees to the city, correct? Correct. And then, where are we at? Is this under 2? And then, will they be able to obtain a building permit within 6 months and then complete and obtain a C of O within 24 months after the granting of the variance?
Yeah, he's ready to go.
Okay, very
So,
good.
yeah, we first dealt with Dave Buckley, and then he left, and we've been in communications with Bruce Flowers, and he says the drawings are good. We just had to go through
The
this
process.
process because it was a non-conforming lot.
Okay, thank you. Can I get a motion one way or the other?
Motion to approve.
Second,
All right, we have a motion and a second, and I will take the roll. Judy?
I agree.
Montos?
Aye.
aye.
And I will also vote aye. So you have a granted variance, 4-0. Congratulations to your client.
Thank you.
And so the procedure is I have to sign something at some point? and-
Yeah, so Jordan, what's going to happen is tonight I'm going to send you the final version of the resolution based on your evaluation of the 5 factors. Look it over, add your electronic signature. I know Dave always signed it in person, that's not necessary. Throw a little electronic signature on it and if you're good with it, and
Yeah.
email it back to myself and Amanda, and we'll be good to go.
Very good. Okay, thank you for your time.
You got this.
Good luck with it.
Thank you.
And surprise, I must recuse myself for the miscellaneous business. And Montos, you are I'm going to appoint you what's it?
The acting chair?
The acting chair, is it vice chair? Acting chair, you're going to be the acting chair. But I must recuse myself because Cuddy and Feder is representing me on a project in front of the planning board. So, bye for now.
Okay. I wasn't ready for that one, but here we go.
Don't worry, Montos will walk you through it.
Got a doozy for you.
Okay, so I have to request a motion for this, right?
Nope, this is actually not a public hearing. They are here to request an extension, and so Taylor is here to give an update about where they are in the process, and this is for the Elijah Street project that received the area and use variance, so
Thank you.
take it away.
Good evening, Acting Chair, members of the board. Happy New Year. It's been a minute since I've seen you all.
Same to you.
And so as Drew mentioned, we are before you tonight for just an extension request for the existing approvals for 53 Eliza Street. As you'll recall, that was a use, as Drew mentioned, it was a use variance and area variances for 3 new buildings there. You've all likely driven by Eliza Street in the last so long. The buildings are all constructed. They're all done. The resolutions include a specific condition that says it mirrors the conditions in a building permit. So when a building permit's issued, it must be constructed within 2 years, or they have to go back. So this is sort of like a double dip. We have to come back to you seeking an extension of the area variance approval because we have not finished the buildings, but they will be done within the next 8 to 10 months. That's all the complications related to the pandemic, everything that led to these buildings being finished. But they're all constructed, and they're expected to be done within the next 8 to 10 months with every little thing, whether it's windows, finishings, furnishings. I think one of the buildings is almost entirely complete, and the others have been fully constructed. It's just now finishing the buildings themselves. So we're before you because that condition in the resolution requires that the, not substantial construction, but all construction be completed to mirror the building permits.
I just want to clarify, isn't it, you have to have the certificate of occupancy within that time period?
Well, I can defer to the city's, I would agree with that. That's the easiest way to clarify, but a CO could be issued for each building.
Yeah.
So that wouldn't necessarily satisfy. It says all construction must be complete. So
So how would you interpret that, Drew? Is it CO for all three within that time period?
That's how I would interpret it. And we'd consult with Bruce, but that's how we'd
Yeah.
interpret it. But Taylor, it's my understanding in 10 months, you believe that
Oh,
can
yeah,
be
8 to
achieved,
10
right?
months, we'll definitely have ACO. All three will be, we've anticipated with 8 to 10 months, that'll give us more than sufficient time
Yeah.
Perfect.
to do it. So we've requested 12 months in case there's any other delays to do that, but you've all driven by, it's well underway.
Perfect. Thank you for clarifying.
Thank you.
And Montes, just to give you a little more history, this is technically their third extension request. It has been a very interesting history with this project because the first request was because they were delayed in getting their building permit because of planning board conditions. Then the second request was they got their building permit, but technically the resolution expired 11 days prior, so we just kind of filled that gap to create a clean record. And now this one is they got the building permit, they're building, but now they're at the second half of that condition and the construction's not complete. So they're not here 3 times because of a lack of progress. They're here 3 times because of how the condition is phrased.
Yeah. And Taylor, I think you mentioned that it was potentially COVID-related, right?
The supplies, I mean, they're all wood frame construction, that was cost, everything associated with it, but to your point, Acting Chair, they've diligently pursued the construction. It's all there.
Yeah.
It's just an interesting provision, presumably included in these resolutions to sort of avert someone from applying for a building permit, getting it, and then saying, let me step back, because then you've satisfied the condition, this variance now kind of runs the land. If I were in different shoes, I might say that condition would be unenforceable, but we're here just because, to satisfy the bright line rule of that condition, we're asking for the board's consideration. And I don't even know what would happen if it wasn't extended, because it's so far along as far as vested rights and otherwise for the development of the site. But again, before you this evening, as Drew mentioned, we've been diligently pursuing it. The buildings are constructed. We're just trying to meet the bright line letter of the resolutions.
Great, thank you. I don't have any questions.
So the motion that the board could entertain would be to grant a 1-year extension of the variances to expire on January 18th, 2024.
So do I have a motion?
Motion to grant the extension?
Second.
Okay. I agree with that. We'll just go through.
Aye.
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 Great.
Okay.
Thank you very much. Appreciate your time.
Great job, Montes. Thank you for filling in for me there.
Great job tonight.
Oh, thank you. And I will take a motion to adjourn our January meeting.
Motion?
Second.
All in favor?
Aye.
Aye. And then just for the public, are we on for a Wednesday next month as
No,
well?
we are on for, oh, shoot, are
Yeah.
there holidays?
Yeah. I think we
Whoops.
are.
You too. Take care.
Let's just check that, just
Hold
so
on,
we can.
everyone.
Is it February? Is it President's Day?
It's going to be
Yeah.
February 21st is typically, but isn't the 20th a holiday?
Let's see.
Okay, everyone, we are meeting again on Wednesday.
So it'll be a Wednesday, our next meeting will be Wednesday, February 22nd. Thank you. and good
Thank
night.
you. Good job.
Did we do a motion to close the meeting?
We did.
Okay, I'm sorry.